everyone, how are you doing? Hello, hope you're good, hope you're fine. Welcome to Lawyers Info Hub. It's a great pleasure to always speak to you. Thank you for stopping by to check this channel to watch the content. I'm very grateful. For my returning subscribers, thank you for always stopping by to know what is new. And for you who's watching me for the first time, please do hit the subscribe button. Join this wonderful family, and you will learn something. Your knowledge base will keep increasing by the day. So we're looking at how to challenge an arbitral award. We have discussed in the previous video on the requisites of an arbitral award. Now we're looking at how do you challenge an arbitral award. Yes. Challenging an arbitral award involves that the party who was part of the arbitration, no longer wants to comply with the award giving. So, what are those grounds upon which you can challenge an arbitral award? So, the first one is on lack of jurisdiction. The person challenging an award can come under lack of jurisdiction as a ground to challenge that award. Now, under lack of jurisdiction, the person can be saying that there was no valid arbitration agreement. The person can be saying that the matters submitted to the arbitration panel or the tribunal does not fall within the agreement of parties, for public policy and all of that. Now, when you challenge, you know that even in the common court process, once there is no jurisdiction, the court does not have the power. It is the live wire of adjudication. It is the government. It is very basic. It is the power of the court to proceed. So where there is lack of jurisdiction, is a problem. Where the tribunal is not properly constituted, no valid arbitration agreement, the matters submitted are, outside or not within the contemplation of parties in terms of the arbitration agreement. So these are things, that can be used under lack of jurisdiction. Now, when a party wants to challenge an award, he can do so at the inception of the arbitration or wait at the conclusion of the arbitration when the award is being made. Now, when it is by the rules and by the Act, Arbitration and Conciliation Act, have 3 months within which you can bring, file an objection or to challenge the award after it has been, given. So it is something you do timelessly. There's no delay required. And you just file the application to court on why you want the award to be set aside. Another ground you can use in challenging an arbitral award is procedural ground. You know, most times in international arbitration, this is usually utilized, you know, um, and many people have used it to set aside an award in international commercial arbitration. Now, under this procedural grounds, so looking at maybe lack of the capacity to conclude an arbitration agreement, saying the parties lacked the capacity to conclude on their arbitration agreement. Therefore, an arbitration proceedings can be held, or there's no jurisdiction in it, or the tribunal couldn't have derived their powers from an inconclusive arbitration agreement. Where the aggrieved party who is trying to challenge the arbitration was not given proper notice of the appointment of the arbitral tribunal and was unable to present its case. They're saying, I was not heard, I was not notified. Um, Now, where the matter deal with issues not contemplated within the arbitration clause, the arbitration clause, it's just a brief of what of the arbitration agreement. It is that clause that reflects the fact that parties had in their own agreement made reference or submitted to arbitration when there is a dispute. So where the matters are being dealt with are not contemplated by the arbitration clause or goes beyond the scope of what was submitted. This is also under procedural grounds. Now, it is also important to also know that when a party is submitting these grounds for, you have to state the reasons. You don't just say, I am procedural grounds. You have to state what you mean by your own procedural grounds. It shouldn't be that the composition of the tribunal was not in accordance with the agreement of parties, where the subject matter or the problem or the issue, subject matter of dispute is not capable of settlement by arbitration under the state law or under the law of the where the parties are, where the award is in conflict with public policy. These are also under procedural grounds. So the party who is relying on procedural grounds to challenge that award must state in full details the details or the reasons or what you're really saying. You cannot just bring challenge on just procedural grounds. You must state in specificity or specifically what you mean. Now, where, for example, a party to the agreement was under some form of incapacity. These are so the party bringing the grounds for to or challenging the must state out what you are relying on. Just like when you're bringing a criminal objection in the normal court, you have to state your grounds. You have to state these are my reasons why I feel this award or the judgment cannot stand. So or it also applies in arbitration. So when you're challenging arbitration, you must state your reasons. It's very, very, very important. You know, where the award now maybe goes beyond what the scope of the arbitration agreement. These are also valid grounds. You know, now issue of public policy, I've mentioned that. So the party, as I earlier said, must be specific in terms of the grounds. Now, under you have also ground of misconduct. A party can say there was misconduct in the proceedings. Misconduct in terms of irregularity of proceedings, issue of where, for example, there was an agreement that evidence will be taken orally, and the arbitrators received the agree or the evidence by affidavit. Is a misconduct, where the arbitrators refuse to hear the evidence or of a material witness, um, maybe where the arbitrators failed, to allow translation of foreign documents, you know, maybe where there are two arbitrators and they couldn't agree on certain things, you know, another thing too that maybe there was bias, you know, um, parties, the arbitrators didn't act fairly in their dispositions. So these are things that can come under misconduct. Now, also where the arbitral award was improperly procured, that could be also another ground. You know, where the arbitrators conducted themselves improperly. There's error on the face of the record, error in law. You know, it can also be a ground. Now, just as I earlier told you, whatever grant you're coming under have to come within 3 months. Now, it's also important to know that issue of misconduct is broad. So when you're bringing the ground under misconduct, you must expatiate where exactly you are hinging your ground upon. Now, where an arbitral award tribunal had failed in determining issues put to it. Yeah, these are issues that are the material to the dispute. What these are the major issues parties are fighting over. When the arbitral tribunal was not able to, analyze these issues, it is also a ground upon which you can challenge the award. You know, it's also where parties maybe the arbitrators could not give reasons for their award. They could not provide reasons why they arrived at this particular point. Because you can see in an arbitral award, we have the disputive part. The disputive part is where they have, stated out the orders of the tribunal. Now, sometimes before the dispute, you can state your reasons, or as you're doing your disputive, you put your reasons. If you're, understand the arbitration proceedings, So where there's no reasons, you can't just arrive at a particular decision without some reason prompting you to arrive in that kind of a decision, or that the reason that informed your decision. So these are also issues you can bring up to say, okay, there was no proper analysis, That was just more of an expression of opinion. So that the issues before the tribunal was not properly decided. It could also be a ground for a party to challenge the award. There's a concept of remission. Remission is where there are instances where the court can order that the file containing the arbitration proceedings be remitted back to the arbitrators to work on. This is the concept of remission. Is one of those concepts under arbitration. So sometimes the court can look at it and say, well, these things, let the arbitration panel or the tribunal work on it, and there is order of remission. The file will be moved back to the arbitration tribunal and they work on it. There are various instances, but the major grounds I've listed it and I've discussed it. I just hope you'll be able to learn something. So these grounds are the major grounds people can use or an aggrieved party can use to challenge an arbitral award. I hope you've learned something today. If you're yet to subscribe, please hit the subscribe button, share this video, drop your comments because I want to see your comments, ask your questions. It will be attended to. Do take care of yourself and know that the sky is just your starting point and you can be the best wherever you are and in whatever you are doing. Do take care of yourself.